so I don't get yelled.
All right, welcome to the 294th District Court. My name is Judge Chris Martin. When I call your name, please say present or here, raise your hand so I can acknowledge you for the docket. If I don't hear or see you, I may mark down to issue a warrant for your arrest. So if you don't want that to happen, I don't want that to happen, say present or here, raise your hand. Michelle Daly. Didn't hear you, Miss Daly. You're lucky I saw you. James Johnson. Here. Jason Mulligan. Waiver of arraignment filed. Approved by the court. It's like pre-trial granted for 2/8. Carlos Padron. Carlos David Padron, Padron. Kylena Rochard. Liliana Vasquez. Cody White. Nathan Lewis. Eric Ketchersid. Michael Spruce. Laura Fleming. Grace Fowler. We have reset Miss Fowler.
We've reset
January 25th. I believe January 25th. We have reset her status. Jason Nichols. Jason Eric Nichols. Thanks, sir. Clarence Rowan. Darian Hamner. Hannah Hodge. Stephanie Rios. Miss Beasley outside. Will you see it? Miss Beasley speaking here. Billy Fleming. Tylea Powell. Joseph Simpkins. Miss Rios was out there. Thank you. Jonathan Curtis. Reginald Young. Tanner Sistruck. Matthew Kearns. Matthew Grace. He's in traffic. Thank you, Ms. Lee. Noemi Escobar. Thank you, Mr. Rieta. Christopher Laney. Thomas Meek. Thomas Vincent Meek. Scotty Petty. Charlotte Robinson. Looks like a waiver of arraignment was filed, pretrial set February 8th. Ryan Hare. Jonathan Stanberry. Jonathan Blake Stanberry. Misty Rice. William Robertson. Brandon Smith. Mark Walcott. Motion for continuance, e-filed and granted without opposition. Court has reset Mr. Walcott for February 22nd at 1:30. Keith Thomas. Jan Espino. Robert Schultz, waiver of arraignment, e-filed and approved, pretrial set January 25th. Aaron White, waiver of arraignment, filed and approved, pretrial set January 25th. Jordan Manis. Jordan Wyatt Manis. Augustine Olson. Augustine Olson, I'm sorry, sir. Mitchell Ragland. Mitchell Wade Ragland.
I haven't seen this correct. We will get on that.
Lance Robertson.
Your Honor, I regret to leave my client wrongfully accused in Dallas County. He no better. I don't know how long he's going to be there. I talked with the lawyer. I will stay in touch with the district attorney's office. It sounds like they're getting close to a resolution.
Okay. All right, is there anyone who's in the courtroom whose name I've not called? You have not heard your name called. All right, counsel, if y'all form a line over here so I'll know who's ready on what. Chester knows where to sit. First up. Did you sit in the front of the class?
My goodness, no.
Talia Powell, CR 21306. Ms. Powell, if you'll come to the center podium, please, ma'am.
Judge, we are waiting on this house discovery. It's been made available to us both on the discovery portal and this for now we're getting test. So we just asked for a reset in this case.
Any objection to this statement? No. All right, court will reset. Pre-trial. Are you available January 25th?
Yes, sir.
All right, Ms. Powell, you are reset until January 25th at 9 a.m. Once you sign this notice and get the yellow copy, you're free to go, ma'am. Ms. Powell, I show that you are delinquent on your bond supervision payments of 120. I show that you're delinquent on your bond supervision payments to $120. So I need you to report pre-trial release and get that paid today. Joseph Simpkins, CR 21245.
We are still trying to find a resolution in this case. I spoke with them about that as well. So
All right, no contested pretrial motions. All right, court will set this then for a docket call on January 25th at 9 a.m. Mr. Simpkins, once you sign and get the yellow copy, you're free to go. Jonathan Curtis, 2021-192 and CR 21210. All All right, Mr. Curtis is set for docket call, Ms. Chester.
Yes, that's correct, Judge. We just need a trial date to proceed this.
All right, so Mr. Curtis is unable to reach a plea agreement with the state. And so for the record, can I know what the plea agreement is, so I know what he's rejected? While they're looking that up, Mr. Curtis, you understand that if you don't reach a plea agreement in this case, the court's not going to allow you to reach a plea agreement later. You understand that? So if you ask for a trial, I set up a trial. Friday before you decide you want to take their offer, I'm going to tell you no, and we're going to go to trial. You understand? Okay.
Judge, the last offer the state has in its file is 8 years TDC and a $2,500 fine.
8 years TDC and a $2,500 fine.
Yes, Your Honor.
All right. Court will note for the record that Mr. Curtis has rejected that offer and all other offers made by the state. Court will set Mr. Curtis for jury selection beginning January 10th. So Mr. Curtis, on January 10th, you'll have to report to the basement of the courthouse. And when you're down there, and we'll set that at 8:30, you will not come up to the courtroom. Your case will not be picked for a jury for trial that week. You'll report down there. My staff will be there, and they'll give you the reset date. You'll continue to do that until your case is reached for trial. Ms. Chester is not going to be required to be here on that day, okay? All right, you're free to go.
That's all I have this morning. May I be excused?
Yes, thank you, Ms. Chester. Good morning, sir. Fleming, is that right?
Yes, Your Honor.
Billy Fleming, CR 2119. Mr. Fleming is set for docket call.
Yes, Your Honor. We've executed a waiver of jury trial. We've negotiated a plea with the presented to the court.
Yes, please. Yes.
Thank you. We negotiated a plea, however, we worked out an agreement with the district attorney's office to do that plea first part of February. My January documents are pretty CPS trial and criminal trial.
Okay. Mr. Fleming, if you'll raise your right hand, I'm going to place you under oath, sir. Mr. Fleming, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Mr. Fleming, I have in my hand a waiver of jury trial. Have you discussed this document, reviewed it with your attorney, Mr. Cargill? Do you understand what you're waiving in here? You understand that you have the right to a jury trial in your case, the right to confront the state's witnesses, cross-examine their witnesses, confront their evidence, all in front of a jury of your peers. You understand that no one can take that right away from you. You understand also that you can waive that if you are doing that intelligently, knowingly, and voluntarily. That's what you want to do, not under pressure or being coerced or under duress. Is this your decision that you're making today? And no one's threatened, forced, or pressured you, made you feel like you had to waive your right to a jury trial. And you understand that by waiving it today, if the court accepts it, it may not be restored to you. If you decide later that you don't want to do a plea agreement and you want a trial by a jury, there's very limited circumstances in which a court can restore this to you. You understand that? Okay. All right. Court finds that Mr. Fleming has been admonished as to his right to a jury trial, that he has waived it intentionally, knowingly, voluntarily. Court sees by signature of counsel for the state that the state's joining in waiving their right to a jury trial as well as counsel for the defense. Court hereby approves the waiver of jury trial and will set Mr. Fleming for plea on, do you have your calendar, Mr. Cargill? Can you do February 8th or 10th?
I believe the 10th is available here.
The 10th? All right, Mr. Cargill, you are set for plea on February 10th. Once you sign the notice, and you have a notice of appearance there, Mr. Cargill. Once you sign that and get the yellow copy, you're free to go, sir.
Thank you.
You're welcome, sir. Mr. Kimball, you ready?
Mr. Reginald Young,
Mr. Young,
docket call
CR
today.
2198. So it's the one with small cases.
Conditions, I just can't.
All right, Mr. Young is set for docket call.
That's correct, Your Honor. We have received discovery material and received a plea offer of 8 years TDC. And at this time, we would request a trial date.
All right, Mr. Young, court's going to note that you have rejected the state's offer of 8 years in the Texas Department of Criminal Justice. Court is going to set you for jury selection beginning January 10th at 8:30 a.m. The court is also going to order you to sign your conditions of pretrial release. These are going to be conditions that are associated with your bond that you have posted in this case. It's going to require you to report to a pretrial release officer, to make payments towards that officer, to be drug tested, to pay for that, things of that nature. Violations of that could result in your bond being found insufficient and you being put back in jail. Do you understand? Once you sign that notice, I want you to report over here to these officers and they'll give you more information, okay? And Mr. Young, after that, I want you to report down to the court compliance one. After you speak with these officers and do sign all the paperwork, get all that, I want you to go down into the hall and see Miss LaPrade. I show that you're several $1,000s delinquent on some old cases. If we don't start paying on those, you're going to go to jail.
And Your Honor, that's all I have this morning. May I be excused?
Yes, thank you, Mr. Kimball. So, all right, on the record, CR 2397, State versus Jordan Wyatt Manis. Court finds that Mr. White has filed a waiver of arraignment that was filed, looks like sometime first week of December. Courts received that today. Court's approving it and setting pretrial for January 25th at 9 a.m.
I'm sorry, Judge, who is this?
Jordan Manis for Mr. Nolan White, CR 2397.
Thank you, Judge.
Mr. Smith, you ready?
I am, Your Honor. Ryan Hare, please.
Mr. Hare. This is Ryan Lee Hare, CR 21218. Oh, I just want some paperwork, so I know what we're doing. I can spit out a plea, but it might not be what y'all agreed to. No, I just want to get rid of it. Yeah, this was not what I was thinking, so good thing that I got the paperwork.
Yes, sir.
Could you fill this up for me? Just fill out all of it at the top.
Oh, I'm sorry.
Sure, all of this. All right, Mr. Hare, if you'll raise your right hand, so I'm going to place you on oath. Mr. Hare, do you swear that the testimony you give to the court today will be the truth? Thanks, sir. The truth, the whole truth, and nothing but the truth. So if you got, all right, you put your hand down. Mr. Hare, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Brian Schmidt. Are you pleased with his representation of you?
Yes.
You feel like you've had enough time to discuss the case with him, have all your legal questions answered? Is there anything about this paperwork in this case that, in the paperwork that you've read, signed, that you do not understand? Mr. Schmidt, do you believe Mr. Hare to be competent today?
I do, Your Honor.
Have you explained to him all of his legal and constitutional rights?
I have, Your Honor.
And do you believe he understands those?
I do, Your Honor.
Mr. Hare, it appears that you were indicted with a state jail felony offense of driving while intoxicated with a child under 15 years of age. However, it looks like the plea agreement in this case is that you're going to plead guilty to a lesser included offense, Class A misdemeanor, driving while intoxicated with a blood alcohol concentration of greater than or equal to 0.15. A Class A misdemeanor carries a range of punishment of confinement in the Van Zandt County Jail for no more than 1 year, or a fine not to exceed $4,000. You understand that range of punishment? And I see here that the plea agreement is that you would plead guilty to that charge in exchange for the state's recommendation that your sentence be set within that range at 12 months in the county jail, with that being suspended and you being placed on community supervision or probation for 12 months with a $1,500 fine plus court costs and reimbursement fees. Is that your understanding of the plea agreement? And that's what you want the court to approve? All right, Mr. Hare, then how do you plead to driving while intoxicated with blood alcohol concentration of greater than or equal to 0.15? Are you pleading guilty to that charge because you are guilty of committing that crime? Has anyone threatened, forced, or pressured you to make you feel like you had to plead guilty today? Court accepts the defendant's plea of guilt. Mr. Schmidt, any objection to States 1?
No, Your Honor.
States 1 is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we would rest and close.
For the defense?
No, Judge. Probation, and he has it, the information sheet.
Are you talking about for interlock or?
No, he already has it interlocked, condition law, but the dash probation, he has that with him, so.
Okay. Well, yeah, just a minute when I get through to it.
Yes.
All right, the court has reviewed the evidence, and I do find sufficient evidence to convict Mr. Hare of this offense. The court will follow the plea agreement in this case. Court convicts Ryan Lee Hare of driving while intoxicated with a blood alcohol concentration of greater than or equal to 0.15. Court assesses his punishment at 12 months confinement in the Van Zandt County Jail, with that sentence being suspended and being placed in community supervision for 12 months. Court orders him to pay a $1,500 fine, court cost of $270, and reimbursement fees of $35. Mr. Hare, have you ever been on probation before? Is this your first criminal offense? You know, a lot of people think that probation is a slap on the wrist, that there's no punishment, that people get to walk away after committing a crime. And anyone who's ever been on probation, especially a felony probation or even misdemeanor probation, would tell you that's a lot of hard work. It takes accountability, it takes responsibility, it takes being an adult, making wise decisions to be able to successfully complete. That's what they would tell you, right? I think the inverse is true. It's easier to be locked up and sit in a room and do your time and be told when to use the bathroom, when to eat, when to go outside, when to have gym time, and all those things. That's easier. It's like being a child, being told what to do, being fed, being housed, being clothed, right? So you got a responsibility that's it's going to take accountability and hard work to do what you're supposed to do, but it's something that can be done. And, you know, I would say that after reading the evidence in your case, it's very fortunate that you got pulled over. Because who knows, maybe you're a mile or two down the road, you had a wreck, killed your daughter. And I know this is probably something, I know Mr. Smith's probably talked to you about this, but I would be remiss if I didn't say it. You're lucky. You're lucky you're on probation today. Not because you're on probation. You're lucky because you get to see your daughter later today if you want to. You get to call her, you get to talk to her, you get to hold her, tuck her in, take her places, take her to school. Been a lot of men and women that have stood right there where you are, and they couldn't say that because they had to bury their child because they made these decisions. All right. So hope this is the last time. Hope this is a wake up call for you. Okay. Mr. Harry, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted with the bailiff.
That's all I have.
Yes, thank you, Mr. Harry. Ms. Beasley? Are you ready?
Mr. Hamner, Your Honor.
Gary and Hamner, CR 21-1358. Am I saying that right? Is it Gary? Okay. Mr. Hamner is set for arraignment today, Ms. Beasley.
He is, Your Honor. May I begin?
Please.
Mr. Hamner understands his charges, Your Honor. He understands punishment range and wishes to enter a plea of not guilty this time. Your Honor, I've been in negotiations with the DA's office. I think one additional setting, hopefully with the court's permission on January 4th, we'll know if I'm going to be able to resolve this case and not have to hand it over to somebody else. I'm hoping that we're going to be able to resolve it shortly.
Fortunately, January 4th is a jail docket only.
Oh, I'm sorry.
Do you want to put him in custody and we do it on?
Well, no, sir. Don't want that. What day do you have available?
I have that following Thursday, the 6th.
Then we'll make that happen, Judge.
All right, court will enter Mr. Hamner's plea of not guilty into the record. We will set this for pretrial on January 6th at 9 a.m. Mr. Hamner, once you sign and get the yellow copy, you're free to go. Okay.
Hannah Hodge.
Do you want to get him? Here's what.
I'll meet him out in the hall, Judge.
Hannah Hodge, CR 21-292. Hodge is set for pretrial today.
Yes, sir. We'd ask for an additional pretrial setting. The offer's been made a pretrial intervention contract. We just have to come up with the money. We think we'll be able to have the money towards the end of January.
Are there any contested pretrial motions?
No, Your Honor.
Court will set this for a docket call. You said towards the end of January.
Yes, sir.
You're going to be holding over.
I will for the ones I can get resolved. Yes, sir.
How about January 25th?
Yes, sir.
All right, Ms. Hodge, court set you for January 25th at 9 a.m. Once you sign and get the yellow copy, you are free to go.
She's got the paper.
Stephanie Rios, CR 21-309. Ms. Hodge. Ms. Hodge, will you report to pretrial release for me, please?
I think he already got it.
Ms. Rios is set for pretrial, CR 21-309.
That is correct, Judge. I believe we have a resolution on this case, Judge. However, my client, it is for prison time. My client would ask the court to reset her case to February the 10th, and we'll do a plea at that time.
Any objection from the state?
No, Your Honor.
It's set for pretrial today, so I would grant you that date anyway. So February 10th.
February 10th, Judge.
All right, court will set Ms. Rios then for plea on February 10th at 1:30.
1:30.
She'll just report out to the justice.
Yes, sir. May I
Yeah, ask Ms. Beasley, and if I need to address it, I will. Any issues, Ms. Beasley? Okay, all right, we'll see you back on, you don't need Ms. Rios.
may I be excused for
Yes,
this
thank you.
afternoon, Judge?
Yes, thank you. Ms. Beasley. Noemi Escobar, CR 21286. Good morning, Mr. Rada, how are you?
I'm great. So,
Good. All right, we are set for pretrial. Are there any pretrial motions today?
no, Your Honor, at this time, we're requesting additional settings, so I have not been able to meet with this Ms. Esquivel to review discovery, so we're requesting additional time to do so.
Any objection from state?
No, Your Honor, we've been in discussion with Mr. Rita. That's our understanding.
All right, are you available on January 25th?
That would be fine, Your Honor.
All right, Ms. Escobar, we're going to set you for an additional pretrial on January 25th at 9 a.m. Once you sign this notice of appearance, get the yellow copy, you're free to go.
Thank you.
Yes, thank you, Mr. Rada. Morning, Mr. Harden. Tanner Sistruck, CR 21189. Yes, sir.
We've got a plea that we've agreed to today. And we have an open setting. He's just taken a job at the field. He'll come back, do a plea. If I can get a week's notice in advance and then get him set on the docket at any time the court pleasure.
You have a date. Wait, here, let me go ahead and call it so we can get everybody in on this. This is CR 21189 State versus Tanner Sistruck. And Mr. Sistruck is set for docket calls. I'm understanding that y'all have worked out a plea agreement.
We have, Your Honor.
And we just want to set it for a plea.
Yes, Your Honor.
All right, and are we waiting for enough time to gather up money or to, is it involve any time or anything?
The only thing involving time, Judge, is Mr. Sistrunk has accepted a job in the oil field and he's got to go report and then he gets 20 days up and then he comes back home. And he'll complete the plea at that time and take care of the sentence that the court has ordered.
Does he already have a schedule in mind that he knows when he would be back?
County process and Rick Coleman, that's all this. I gotta get there, so I'm not sure I got a rough estimate, but I could give a certain date.
What's your rough estimate?
I'm supposed to leave and be there on the 23rd this month, be there for 20 days. And back 15. But they said the first time you're there, they usually get 8 days. So we do 20 days of work, 10 days off, and then another 20. It's your schedule. So you just work over the basis.
Any objection? We set this in February.
Judge,
And I see a waiver of jury trial.
Okay, as long as the waivers from your state has no objection.
All right, so this is what we'll do. I'm going to discuss the waiver of jury trial and then we'll set it for late February. Maybe that'll set him out. And then if late February comes and we know what his schedule is, if we need to reset it, we can.
Thank you, Your Honor.
All right, so Mr. Sistrick, raise your right hand. I'm going to swear you in, sir. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Mr. Sistruck, I hold in my hand a document that's entitled Waiver of Jury Trial. Have you read this with your attorney, Mr. Ron Harden?
Is that, I'm not sure if I 100% understand that one, but I believe that it's a waiver of jury trial where.
Okay. So what this document says is that you're represented by your attorney, Mr. Harden, and that you understand that you have the right to have your case tried before a jury of your peers. You understand that you may waive that right. And that if you waive that right, you're waiving the right to confront the state's witnesses and their evidence in front of a jury. You would be releasing a jury trial and you would be substituting the court as the trier of fact if you wanted a trial. And once you waive your jury, it's not going to be restored to you. Understand that? So what I'm hearing is that there's a plea agreement between you and the state, but that you would be waiving your right to a jury trial today. So what that means for you, Mr. Sistrunk, is if later you change your mind and you decide, hey, I do not want to do that plea agreement, you could still have a trial in your case, but the trial would be before me. I would listen to the evidence. I would listen to the witnesses, and I would determine if you're guilty or not guilty. And if you are guilty, then I would determine punishment.
Still like to talk to you. I'd still like to talk to you about that.
Yeah, go ahead. Go ahead. Go ahead and step to the side. I'm going to take some of the other attorneys that are ready and we'll recall your case. Who else is ready over here? You're next, right? Yeah. I'll try to keep up with my line over there. All right, Nathan Lewis. Is this PTI going to have any of the assault requirements in it? If it's an injury case, or I noticed that nothing's checked on.
I don't believe so. Double check on that.
Mr. Lewis, if you'll raise your right hand, sir. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right. Is your name Nathan Howell Lewis?
Yes, sir.
And Mr. Lewis, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, Your Honor.
And in this case, you are represented by your attorney, Ms. Carrie Ann Bradford. Are you pleased with her representation of you?
Yes, sir.
You feel like you've had enough time to discuss the case with her and have all your legal questions answered?
Yes, sir.
Is there anything about this paperwork that you've read and signed today that you do not understand?
No, Your Honor.
Your Honor, the state is not going to request any special conditions.
And Ms. Bradford, do you believe your client's competent to enter into this contract today?
Yes, Your Honor.
And Mr. Lewis, is this your true and correct signature? And did you only sign once you were certain you knew what you were signing?
Yes, sir.
All right, Mr. Howell, I see here that there's an allegation of injury to a child, elderly, or disabled individual with bodily injury, a third-degree felony. See that you have not been indicted by the grand jury. However, you have executed a waiver of indictment. Have you discussed that with your attorney, Ms. Bradford?
Yes, sir.
You understand that you have the right to have your case presented to a grand jury, for that grand jury to determine whether or not there is probable cause to believe that you committed a crime, and only if they made that decision that there was, would the case go forward for prosecution. You understand that by waiving your right of indictment, you're allowing the state to move forward with the prosecution without going to the grand jury. And this is a decision that you made of your own free will. Has anyone threatened, forced, pressured you to make you feel like you needed to waive your right to an indictment? Right, and Ms. Bradford, you discussed this with your client, and you believe that he's doing so voluntarily.
Yes, Your Honor.
The court will find that he has been admonished as to his waiver of indictment. The court finds that he has intentionally, knowingly, and voluntarily waived his right to indictment. Now, I see that there is an agreement for you to enter into a pretrial intervention contract with the state on this charge for a period of 1 year. Have you read over this contract? You understand everything that's expected of you. You also understand that you are waiving some very important rights, such as your right to a jury trial. You understand that that is it's a right that cannot be taken away from you, but you can waive that if you're doing so of your own free will. You also understand that you are waiving your right to a speedy trial, and you're also waiving the right to have certain criminal records expunged. And you've gone over all of those things with your attorney, and you feel like you understand everything.
Yes, sir.
And you want the court to approve this contract, is that right?
Yes, sir.
All right, the court will find that Mr. Howell has intentionally, knowingly, voluntarily waived his right to a jury trial, to a speedy trial, and has executed a limited waiver of expunction of certain criminal records. Court will approve the pretrial intervention contract. Will place Mr. Lewis on this program for a period of 1 year. All of the terms and conditions set forth in the contract as applicable. Mr. Lewis, you understand that if you fail to complete the terms and conditions of the contract, you could be brought back before this court, placed on the court's trial docket. This, Isaac, just need some guidance on some of these things that aren't checked off. These apply.
Your Honor, just number 1 and 2 down there, but I believe that both of those are.
As I was saying, if you violate the terms and conditions of the contract, the state could notify the court, bring you back here. We would set you on the trial docket, and your trial would be before the court. It would not be before a jury of your peers.
Yes, sir.
And in that trial, the state would be able to offer certain evidence that you have stipulated to as relevant evidence that would be admissible in trial without objection. Understand that? All right, you feel like you understand everything and you want the court to approve that, is that right? All right, the court has approved the placement of Mr. Lewis on the pretrial intervention contract. Yes, please. Signs everything. All right, Mr. Lewis, if you'll come forward, we'll have you report to probation department, and they'll give you further instructions on what to do next. Mr. Sistrunk. All right, we're back on the record with CR 21-189, State of Texas versus Tanner Garrison Sistrunk. All right, so let's go back and talk about the waiver of jury trial. Do you want to clear up any concerns that Mr. Sistrunk had? Okay. So, Mr. Sistrunk, you understand the tenets of the waiver of jury trial? You understand what the waiver of jury trial means and what effect it has?
I do now.
Okay, good. And you want to go forward with it? And that's you're doing so of your own free will, is that right? All right, court will approve the waiver of jury trial for Mr. Sistrick. Court finds that the state has joined waiving their right to a jury trial and that Mr. Sistrick has done it with the advice of counsel. Court sets Mr. Sistrick in for February 22nd. Are you available on that day, Mr. Horton?
Yes, Your Honor.
All right, February 22nd at 9 a.m. And so, Mr. Sistrick, once you sign the yellow copies, or once you sign and get the yellow copy, you'll be free to go. Yes, sir. Yes, that all you have, sir. Good to see you. Stevens, you ready? Misty Rice, CR 2133. Misty Rice. All right, are you Misty Michelle Rice? Ms. Rice, if you'll raise your right hand, I'm going to place you under oath. Ms. Rice, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Ms. Rice, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Bill Stevens. Are you pleased with his representation? Do you feel like you have had enough time to discuss your case with him and understand everything that you've read and signed in the paperwork today? Mr. Stevens, do you believe Ms. Rice to be competent today? Yes. You've explained to her her legal and constitutional rights? Ms. Rice, I see that you were originally indicted with a state jail felony offense of possession of a controlled substance of affiliate group 1 less than 1 gram. However, the plea agreement is that you're going to plead guilty to possession of a controlled substance as a Class A misdemeanor, with the punishment being assessed as a Class A misdemeanor under Section 1244B at 1 year in the county jail, with that sentence being suspended or probated, and you being placed on probation for 2 years with a $3,000 fine and $180 restitution, plus court costs and reimbursement fees. Is that your understanding of the plea agreement? The range of punishment, Ms. Rice, for a Class A misdemeanor is confinement in the county jail for a period of not more than 1 year and a fine not more than $4,000. And I would find that this proposed plea agreement fits within that range of punishment. So understanding the range of punishment and the plea agreement, you're asking the court to approve this plea today. Ms. Rice, how do you plead to possession of controlled substance affiliate group 1 less than 1 gram Class A misdemeanor? Are you pleading guilty because you are guilty of committing that crime? Has anyone threatened, forced, or pressured you to plead guilty today? Court accepts the defendant's plea of guilt. Mr. Stevens, any objection to States 1? No. States 1 is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we would rest the close.
For the defense?
Rest the close.
All right, the court has reviewed the state's evidence. Court finds that there is sufficient evidence to convict Ms. Rice of this offense. Court will follow the plea agreement in this case. Hereby convicts her of possession of a controlled substance of penalty group 1 less than 1 gram. Court assesses sentence under section 1244B of Texas Penal Code at 1 year in the county jail. Suspends that sentence, places her on community supervision for a period of 2 years. Assesses a $3,000 fine, orders her to pay $180 restitution, $270 court costs, and $535 in reimbursement fees.
Everybody gets.
I would be highly.
We all agree.
Ms. Rice, I couldn't help but notice that in your evidence that you were honest with the officer about having methamphetamine paraphernalia on you before you got into the jail. And that kept you from getting a higher charge. Shows you that honesty is the best policy. Even when there's circumstances, even when there's consequences, that could have got you a much higher charge. And so honesty has led you to a place where you're getting a misdemeanor probation today instead of probably felony prison time. Remember that. Ms. Rice, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. And have you step forward with the deputy to be fingerprinted.
Judge, that's Miss Rice on top of those. Thanks, guys.
Brandon Smith. CR 14193. Mr. Smith, if you'll raise your right hand, sir. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. All right, Mr. Smith, you were here on the state's motion to adjudicate your guilt. It appears to me that you were before the court on August 15th of 2017. You pled guilty to criminal trespass, class 8 misdemeanor. The court heard the evidence, found enough evidence to convict you of that offense. Court, however, deferred a finding of guilt, placed you on community supervision for 2 years. Your period of supervision was extended for an additional 2 years in August of this year. You also had a fine assessed. It's been during the period of your community supervision that the state has alleged that you have violated the terms and conditions of your community supervision, and they filed state's motion to adjudicate and revoke. Have you, in this motion, is there just one page to this thing? Just a single count? It seems like, is there another page though that has the state signature on it?
Judge, I didn't see the packet. I thought maybe I did look twice.
Judge, I'll look real quick.
Looks like, Mr. Stevens, there is going to be a second page at count 2, so I'm going to have you show that to your client just a minute. Mr. Woodwhite, check that. It's going to be community service. I mean, allegation of community service. Okay, Brandon.
All I have is one count on one page.
On my copy here, I just printed it out. Yeah, there's 2 pages. There's a
Okay, that's all the DA's office has. From.
I figured about an office.
Go to state handle this when they do the storm.
So here is place. Take it all of that. So I'll count 2 real quick.
Yes, sir. We're good, Your Honor.
All right, Mr. Smith, you appeared before the court on August 15, 2017, and you pled guilty to the aforementioned criminal offense, and the state has alleged 2 counts as to ways that you have violated your community supervision. Have you had an opportunity to review that with your attorney, Mr. Stevens? Can you understand everything that's being alleged? And Mr. Stevens, does your client waive the formal reading of the state's motion to adjudicate?
Yes, sir.
Is it his intent to plead true to both counts?
Yes, sir.
I see that the plea agreement is that upon a plea of true to counts 1 and 2, the state's recommending that his guilt be adjudicated, his community supervision be revoked, he be sentenced to 77 days confinement in the county jail, with him receiving credit for 77 days of time served already, with him being ordered to pay the balance of his financial obligations, which include $500 reimbursement fees and $70 court costs. Is that correct?
Yes.
Is that your understanding, Mr. Smith? All right, Mr. Smith, then how do you plead to counts 1 and count 2 as alleged in the state's motion to adjudicate? Are those counts true or not true? And you're telling me that they're true because what's alleged is true, right? And has anyone threatened or forced or pressured you to make you feel like you had to plead true to either count? All right, court accepts the defendant's pleas are true. Mr. Stevens, any objection to state's evidence?
No.
State's evidence is admitted. Court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we addressed it once.
The defense? All right, Mr. Smith, court hereby adjudicates your guilt, convicts you of criminal trespass, assesses your punishment at 77 days confinement in the Van Zandt County Jail, awards you 77 days credit towards that sentence. Court orders you to pay $70 court costs and $500 reimbursement fees. So, Mr. Smith, after you leave here, what I want you to do is report to, are you gonna be able to pay this off today? All right, so go to the end of the hall and meet Miss LaPrade. If she tells me that you don't come in there and meet with her today, I'm just gonna go ahead and issue a warrant for your arrest. Okay, well, I'm just telling you what happens if you don't. Then we'll be right back in here, okay? Well, I noticed that you had all your other stuff paid off, so I figured that you would, but. Well, you're close then. You're close to having the government out of your life. All right, Mr. Smith, hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. Have you come forward and be fingerprinted with the bailiff. William Robertson. All right, this is cause number CR 21-142, CR 21-151. We're set for docket call today.
Yes, Your Honor, we worked out.
Is it gonna be for probation or time?
Yes, sir. Be ready for probation.
All right. Are you available on January 25th?
Yes, sir.
All right, Mr. Robertson, the court's going to set you to enter your plea before the court on January 25th at 9 a.m. Here's some things I want to address in the plea. I show that you're delinquent $360. You haven't paid $60 towards your bond supervision, and you're delinquent $300 towards your attorney payments on your conditions of pretrial release. So I'm going to want those amounts reflected in the plea agreement. Okay. All right, that or they need to get paid off before then. Once you sign and get the yellow copy, then come check in with pretrial release and you'll be free to go. Ms. Lee, are you ready? You ready, Matthew Grace? Are you standing there for Ms. Payne? Matthew Grace. CR 2167. We're set for docket call. I see that Mr. Grace wants to accept a plea agreement with the state. Mr. Grace, if you'll raise your right hand, sir. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Mr. Grace, are you a United States citizen?
I have.
Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? And in this case, you're represented by Miss Amanda Payne. Are you pleased with her representation of you? Okay, can you tell me why?
Her absence, don't do some of the things that I think we're supposed to have. And the timeline for sex work done.
Such as?
Such as, after spending 9 months in Van Zandt County Jail, the goal then was for me to go to Tarrant County. So we are going to here, Tarrant County to sign that case that I have, which was a break for 2 years TDC. So went to Tarrant County, signed the 2, and she became absent. What she was supposed to do, with the understanding, was that she
once I sign for that too, it will present that to the DA that he agreed to do it to, as a fine. And I was gonna sign that then and go to the penitentiary for both of those crimes at the same time. And, but that never happened, so I did go, and I'm out on parole right now, so I had to go to the penitentiary. They let me out on parole, for weeks now, and I would have loved for that to happen. You know, that was the plan. That was why I did PR bonding out of the county here, to sign on the county there. So that we could get them both together. Of course, it'd be better off overall for the life, but it didn't happen. So now I'm out again. I've just been a year, almost to the day in jail. I am taking a plea for the probation and the extended time because I want to go back. I got, you know, I'm trying to recover now from things I've done. And I've got my own place again, you know, I hate to give all that up. You know, I know that the offer for 2 is still there. I believe is what Amanda told me. But I don't want to do that. I don't want to have to go back in and go back to the system. And possibly have to sit another year in there if I didn't make parole for whatever reason. So I feel that, you know, she abandoned me when I trusted her. You know, she took a lot of money from us. And I don't have that kind of money to just throw around. So let me in a bad position. You know, I had to go anywhere, pay $2,500 to her to get started. Here I am. She's not here. You know, I understand that she worked this plea deal, but that's, and I know that this is all my fault in here and everything that I did, but I just upset. I feel bad by her, and I feel let down. So I know there's nothing else. So that's why I'm specific.
Well, that's why I asked.
Yeah, all those things.
So I've heard what you said and I understand. Understanding that, do you still want to go forward with this plea? And Ms. Shonda Lee, licensed attorney here in the state of Texas, is standing in for Ms. Payne. Do you consent to her standing in for you to conduct this plea?
Yes, sir.
And you've gone over all the paperwork with Ms. Lee, and has she explained it to you?
Yes.
You feel like you understand everything that you've read and signed? Okay. All right, and were you going to say something else?
That's it, sir.
Okay. And Ms. Lee, have you explained all the paperwork to Ms. Payne's client?
Yes, Your Honor.
And do you believe that he understands it?
Yes, Your Honor.
All right, so Mr. Grace, you are charged by indictment with possession of controlled substance, Appellate Group 1, greater than or equal to 1 gram, less than 4 grams. Range of punishment for that is a 3rd-degree felony is confinement in TDC for not less than 2 years or more than 10 years, and a fine not to exceed $10,000. And I see that the proposed plea agreement, as you've stated, is punishment be assessed at 10 years confinement in TDC with that sentence being suspended and you being placed on community supervision for 4 years with a fine of $2,500, $180 restitution, $290 court costs, and $40 reimbursement fees. Is that your understanding of the plea agreement?
Yes, sir.
And that's what you want the court to approve today? All right, Mr. Grace, then let me ask you then, how do you plead to possession of controlled substance in penalty group 1 greater than or equal to 1 gram but less than 4 grams? Are you pleading guilty to that crime because you did commit that crime and for no other reason? Has anyone threatened, forged, or pressured you to make you feel like you had to plead guilty today? All right, court will accept the defendant's plea of guilt. Ms. Lee, any objection to states 1?
No objection, Your Honor.
All right, states 1 is admitted and the court takes judicial notice of the defendant's judicial conviction. Is there anything further from the state?
No, Your Honor, I would state that Mr. Grace's understanding of the situation are correct. There were multiple arrangements made that were never followed through, but we do believe this is in the best interest of justice for Mr. Grace. The 2-offer was still open, but we would ask the court proceed today on this. We rest to close with that.
Anything further from the defense?
Rest of the-
And Mr. Grace, with you stating all of that and you being unpleasant or being unhappy with Ms. Payne's representation, do you feel like you still want to go forward with this plea? if I didn't say so already, the court accepts the defendant's plea of guilt, admits State's Exhibit 1, and takes judicial notice of the defendant's judicial confession. All right, the court has reviewed the evidence, finds that there is sufficient evidence to convict the defendant of this offense. Court will follow the plea agreement in this case. Court assesses or convicts Mr. Grace of possession of a controlled substance of Penalty Group 1 greater than or equal to 1 grams, less than 4 grams. Assesses his punishment pursuant to the plea agreement at 10 years confinement in the Texas Department of Criminal Justice. Suspends that sentence, places him on community supervision for a period of 4 years. Orders him to pay a $2,500 fine and $180 restitution, $290 court costs, and $40 reimbursement fees. Mr. Woodward, do we typically put that the sentence commences on this date if it's a probation case? I don't know if I've seen that.
Unaware, Judge. I'm comfortable with the court interlineating. I don't believe normally if it's a suspended sentence, it wouldn't commence this day.
I mean, it does say that the sentence is suspended. I mean, I think it's okay. I haven't noticed that before.
However, the court feels comfortable, Judge.
All right, Mr. Grace, you're hereby remanded to the custody of Van Zandt County Community Supervision Corrections Department, so they carry out the terms and conditions of the sentence. Have you step forward to be fingerprinted with the deputy. After that time, we're over here to officers and they'll give you further information. Okay. And then I want you to circle around and see Miss Tabraham before you leave. Okay.
Good luck, Mr. Grace.
Yes, thank you, Ms. Lee.
Is that all right? Yeah. Appreciate it. Yeah.
Patty?
Mr. Hyde, you ready? Yeah, let me do this. Matthew Kearns, CR 2199, set for a docket call. Go ahead, Mr. Hyde.
Anyway, it's great to come up with in this case. It's a that purpose of documents. It's the final announcement.
States in agreement, Your Honor. I know Mr. Hyde has been in constant communication with Ms. Curry on this. So just one more final docket call, the court would grant that.
Available on January 25th.
Trial that Hopkins trial for the judge.
to get out of it. I can have you here, you file a motion continuous there. What about January 6th? February 8th? All right, Mr. Kearns, you're set for docket call on February 8th at 9 a.m. Once you sign the notice of setting, get the other copy, you're free to go. Go ahead, Rick.
Yes.
I got your waiver thing sorted out on Manus. They brought that to my attention. So
We filed that, but we said we did it, we didn't do it.
yeah, well, there's a week or so, I think, that may have coincided with you filing that our e-file system was being transferred over on the state level. And it was on the blink for a week. I think it was during that week, so it never got presented to me. So anyway, I got that signed today and I put it on the record. I think you were.
Well, I gave my paralegal work.
That's what you paid the big bucks for, so. Augustin Olson, CR 21364. Mr. Olson, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you may put your hand down. Is your name Augustin Walter Olson?
Yes.
Mr. Olson, are you a United States citizen?
Yes.
And Mr. Olson, have you ever been diagnosed with any type of mental condition? And in this case, you are represented by your attorney, Mr. Nolan White. Are you pleased with his representation of you?
Yes.
Feel like you've had enough time to discuss the case with him, have all your questions answered?
Yes.
Is there anything about the paperwork that you've read and signed today that you do not understand? Mr. White, do you believe that Mr. Olson is competent today? Have you explained to him his legal and constitutional rights?
Your Honor, I believe that Mr. Olson is competent, understands the procedures and opinions against him here today. I also explained his rights, we can waive those rights, knowingly voluntarily.
All right, Mr. Olson, you are originally charged, let's see here, with state jail felony possession of a controlled substance in penalty group 2 less than 1 gram. I see that the plea agreement would be to a lesser offense of a class A misdemeanor possession of controlled substance under section 1244B. The range of punishment for a class A misdemeanor is confinement in the county jail for not more than 365 days and a fine not more than $4,000. I see that the plea agreement would be that you would plead guilty to that charge as a class A misdemeanor with a recommendation that you receive 2 days confinement in the county jail as your punishment, with you receiving credit for 2 days of time already served, and then being ordered to pay a $3,000 fine plus restitution, court costs, reimbursement, and the state is agreeing to dismiss the possession of marijuana case. Is that your understanding of the plea agreement? Yes. All right, Mr. Olson. Understanding the plea agreement and the range of punishment, how do you plead to possession of a controlled substance in penalty group 2 less than 1 gram class A misdemeanor? You're pleading guilty to that crime because you were guilty of committing that crime? Yes. Has anyone threatened, forced, or pressured you to plead guilty today? No. All right, court accepts the defendant's plea of guilt. Mr. White, any objection to the state's evidence?
No, sir.
The state's evidence is admitted and the court takes judicial notice of Mr. Olson's judicial confession. Anything further from the state?
No, Your Honor, we rest.
From the defense?
Rest of the
All right, the court has reviewed the evidence. I do find sufficient evidence to convict the defendant of the offense. The court will follow the plea agreement. Court convicts Mr. Olson of possession of a controlled substance, milligram 2 less than 1 gram. The court will assess his punishment under section 1244B at a class A misdemeanor at 2 days confinement in the county jail, with the defendant receiving credit for 2 days' time already served. Court will order him to pay a $3,000 fine, $180 restitution, $270 court costs, and $35 reimbursement fees. Court also takes into consideration under section 1245, cause number 2021323, possession of marijuana less than 2 ounces.
No, the court that court compliance, court compliance officer set up a payment plan.
Is that right, Mr. Olson?
Yes.
Okay. Down at the other end of the hall, going that way on your left, meet with Miss Bonnie LaPratt. She'll get you set up. Failure to do so will result in a warrant being issued, okay? So let's avoid that if at all possible. All right, Mr. Olson, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted with the bailiff. Let's go ahead and call Robertson. We'll do your bit on that. CR 21338, State versus Lance, Allen Robertson, set for arraignment, and whose announcement was wrongfully accused in Dallas County, right? Being held there. All right. And okay, so let's reset his case. We'll set the status on custody. We'll set up arraignment and status on custody. Do you know when you're going to be back in January? You'll be back January 25th. Do you know?
That's fine.
All right, January 25th for arraignment and status. What about Mr. Ragland? Do you know if he appeared?
Your Honor, I had to check my text. Mr. Ragland contacted our office this morning. He go over home his car and broke it down. He's getting it towed. I talked to the state. The state has indicated to me that they're going to ask the court to issue tickets on this. I'm going to ask the court to say reject, to hold it. I'll be here on Thursday.
Okay. All right, court will issue a judgment nisi in CR 21185, State versus Mitchell Wade Ragland. Court will take that nisi under advisement until 12 p.m. on Thursday, December 16th. And so that you're aware, Mr. Ragland, KP's profile needs to address for compliance officer.
Yes. Where that was to.
Okay.
Mr. Robertson's.
Now, Mr. Robertson. CR 21338.
Your Honor, I'll see you
On Thursday. That's right, you did. Jan Espino, calls number CR 21113, CR 21114, and 115. Sure, we were set for status. What were we set for status for?
Your Honor, that's for that's this case, to be fairly involved.
evidence of this case.
The objection is taken. All right, court will set Mr. Espino for this. Is there any issues with discovery or anything else that we're sorting out? Just a timing issue. Just a timing issue. I understand timing issue, but I just want to make sure there's no discovery. All right, Mr. Espino, the court's going to set you for docket call on February 8th at 9 a.m. on all of your cases. Once you get the yellow copy, free to go, sir.
I believe that's all I've got, Judge.
Thank you, Mr. Wright. Yes, sir. Appreciate it. Judge, ready?
I was obtained on this one.
Colleen Richard,
Sorry,
Richard.
yes, she said.
CR 21-337, Kylena Richard. Is it Richard or Richard? Richard? All right, this is CR 21-337. Ms. Richard is set for arraignment. Go ahead, Mr. Evans.
Thank you, Your Honor. Mitch Adams on behalf of Ms. Richard. Your Honor, I can represent to the court that Ms. Richard has received a copy of the state's indictment, that her name is properly spelled, set forth in the indictment. She understands what the allegation is against her in the indictment. For purposes of arraignment this morning, we are not guilty plea. We waive the reading of the indictment and ask the court sentence for pretrial.
All right, court will enter Ms. Richard's plea of not guilty into the record and will set her for pretrial. Are you available on February 8th or 10th?
Available for February 8th.
All right, we'll set her for pretrial on February 8th. And Ms. Richard will need to sign her conditions of pretrial release after she signs. Once you get the yellow copy, come over here and report to pretrial release, and I'll have additional paperwork for you. Eric Ketcherson, CR 21223. Mr. Ketcherson is set for docket call.
Yes, Your Honor. Mitch Adams on behalf of Mr. Jefferson. Your Honor, we received a plea offer in this case late yesterday afternoon. I have not had time to review the plea offer, discuss the overall options, plea offers. I also suggest, I'd like to think that maybe I can do some further negotiation with the state and maybe sweeten that offer a little bit. Of course, basically what I'm asking for is for to allow us to reset this out for docket call or trial day for the court rather than any time to do this.
Before I entertain that request, let me address some of the delinquencies issues I have. Show that he's over $600 delinquent in his bond supervision, over $700 delinquent in his indigent attorney fee payments. Also show that he owes money on an old case that's probably about to result in a warrant.
I do recall the court had brought this to Mr. Jefferson's attention the previous day. He and I had a conversation about that. Because I slipped my mind and mentioned this to him the previous day. And I just now remember what this is.
Mr. Ketcher said, do you understand what you're ordered to pay each month? How come you're not doing it? Are you on disability? Why not? You're disabled. You understand? We're talking about two different things. You understand that if you are unable to work, I'm not talking about claiming something on insurance or lawsuit or anything of that nature. I'm asking you, if you're not going to be able to work and be employed, then how are you paying for yourself? How you taking care of yourself? How are you feeding yourself? How are you clothing yourself? How are you driving? How are you doing anything? Your mom's doing all that for you? And your mom help you pay off your bond supervision and your attorney fees so you don't go to jail? Well, why not? Okay, well, I'm not asking her to go to jail. I'm just going to ask you to go to jail.
Mom comes back to work every year.
I'm going to give him one last docket call. That's going to be it. He's either going to take it or he's not. And I don't care what he does, but if I don't have some kind of financial, some kind of showing of attempt to pay off what he's been ordered to do, then I'm just going to revoke his bond in the next hearing. We'll just put him back in jail. So we're going to reset this to, are you available on February 8th?
Yes, Your Honor.
We'll reset this to for the final docket call on February 8th.
On behalf of Mr. Sprouse, I don't have any pretrial issues to take up with the court this morning. I'll let the court know that we received a plea offer in Mr. Sprouse's case about an hour ago. Haven't visited with him about it yet. So if the court would indulge us with a reset, then I think we could.
If there's no contested pre-trials, then I'm going to set it for a docket call anyway to give you that time. So
Yes, sir.
court will set Mr. Sprouse in for pre-trial, or I'm sorry, for docket call on February 8th at 9 a.m. And once you get your yellow copy, you're free to go. Oh, no. Okay, yeah, no. Yeah, we've reset. Is that all you have, Mr. Adams?
Until this afternoon, yes, Your Honor.
Okay.
See you then.
Thanks, sir. Be here. Mr. Ashmore, are you ready on anyone?
Judge, I'm ready on all of that. Ask permission to do one thing. May I step out, try to call Mr. Nichols one last time?
Sure, go ahead.
And then we'll communicate everything's through.
Sure if I announced this earlier, CR 2404, Jason Mulligan. I have attorney of record Andrew Damon, waiver of arraignment, e-filed and approved with pretrial set February 8th. Carlos Padron. Mr. Padron, is it true that you have retained attorney Adrian Crane to represent you? I understand, but have you already hired him?
Yeah.
You've already given him money? You've already done that? Okay. He's contacted the court and indicated that you have retained him, but he couldn't make it here in time. So what I'm going to do is I'm going to reset your arraignment. Six, 3-4 on the 6. All right, so Mr. Padron, what I'm going to do is I'm going to reset you till January 25th, and that's going to give Mr. Crane time to file his notice of appearance and start doing the work for you. Okay, so I'm going to have you sign right here. We're going to give you a yellow copy, and then Mr. Padron, I need you to report to pretrial release. I'm going to put you on conditions of pretrial release. You're going to report to pretrial. Everyone has to report when they're on pretrial release. Everyone's going to be on pretrial release. You got to report. You got a drug test. You got to do all these things. Okay. So I'm going to have you come back here and meet with these officers. They're going to have some paperwork for you. Once they get through with you, they'll send you out. Okay.
Let's find it, Chief.
All right. Yes. Who do you want to call first?
Judge, I asked your permission to call Jason Nichols. He did answer the phone
You tell
for
him
me. He's on his way up here.
I say hello.
I told him that if he doesn't want to screw up everything he's got going for him, which is quite a bit, including still a shot at Veterans Court maybe, he needs to be up here. So he said he's on his way, and I told him to report before noon. I know he's
technically already got a nice eye. And we'll just see what the court says when he appears. But I'm ready on Clarence Rowan, who's here on a plea. That'd probably be our longest matter, so.
I'm just going to do that one.
Okay.
CR 2360, Clarence Rowan. So you said that she's here today. She's. Go ahead and do it. Knock it off. Because we got Thursday. You may. Mr. Rowan, if you'll raise your right hand, sir. Mr. Rowan, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so be God? All right, you may put your hand down. You are Clarence Wade Rowan, is that right?
Yes.
And Mr. Rowan, are you a United States citizen?
Yes.
Do you read, write, and speak English?
Yes.
Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Casey Ashmore. Are you pleased with his representation of you?
Yes.
You feel like you've had enough time to discuss your case with him and have all your questions answered?
Yes.
Is there anything about this paperwork that you've read and signed today that you do not understand?
Yes.
Mr. Ashmore, do you believe Mr. Rowan to be competent, and have you explained to him the advantages and disadvantages of a deferred adjudication plea?
Yes, Judge.
And do you believe that he understands those advantages and disadvantages?
Yes, Judge. He's aware that he got a chance to have this deferred dismissed off his record, get his good name back, and the consequence that the range of punishment is open should he mess up on this. I don't think we're going to have those problems. He's already paid his restitution and made some, and is prepared to make the maybe not the balance of his financial commitments to the county, but most of it.
And when you say dismissed off his record, he understands that he can't have it expunged from his criminal record, but he could have it non-disclosed.
Right.
All right, Mr. Rowan, you are charged by indictment with a state jail felony offense of theft of property greater than or equal to $2,500, but less than $30,000. That does carry a range of punishment if convicted and sentenced by a court or a jury to a minimum 6 months up to a maximum 2 years confinement in a state jail prison and a fine not to exceed $10,000. Do you understand that full range of punishment?
Yes.
So if I approve this plea today, and I see that the plea agreement is that you're going to plead guilty, the state's recommending that the court defer a finding of guilt, meaning that the court does not convict you of the offense today. The court place you on community supervision for 1 year with a $1,500 fine plus court costs and reimbursement fees. The court approves that plea agreement today and you violate the terms and conditions of your community supervision within that period, the state can file a motion to a motion to adjudicate your guilt. That means to convict you, and to revoke your community supervision and assess punishment. The court could, upon finding a violation to be true, the court could assess your punishment anywhere between 6 months up to a maximum 2 years in state jail prison, day for day, no parole. You understand that?
Yes.
So understanding the plea agreement, understanding the range of punishment, you want to go forward?
Yes.
All right, Mr. Rowan, then how do you plead to theft of property, $2,500 to $30,000? And Mr. Rowan, are you pleading guilty to that crime because you committed that crime and for no other reason?
Yes.
Has anyone threatened, forced, or pressured you to plead guilty to this crime today?
No.
All right, court will accept the defendant's plea of guilt. Mr. Ashmore, any objection to the state's evidence?
No, Your Honor.
All right, state's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state? From the defense?
No, Your Honor.
Joshua, will you sign that for me since you are here? You just sign there with it. Or you can mark out co-counsel's name, whatever.
Yeah.
All right, Mr. Rowan, the court has reviewed the evidence. I do find sufficient evidence to convict you of this offense. Court will follow the plea agreement. Court will defer a finding of guilt, place you on deferred community supervision for a period of 12 months. Court will order you to pay a $1,500 fine, court costs of $290, reimbursement fees of $590. Hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department, so they can carry out the terms and conditions of the plea. All right, Mr. Rowan, if you'll come forward, be fingerprinted with the deputy, and then report to probation through the source. You're welcome.
She's the one that transferred. Yes. We'll just send it over to her.
Okay, so thank you, sir.
All right, what about Laura Fleming? You ready, Ms. Fleming?
Yes, look, she's out in the hall.
Sit out there.
Ms. Fleming? All right, this is cause number CR 21261, State versus Laura Joy Fleming, set for docket call. Go ahead, Mr. Ashmore.
Good morning, Judge. Thank you. So this morning, we provided evidence to the district attorney's office, which is going to require further investigation. We're asking for an additional docket call. I believe the state is joining us in that request. The plea offer at this time is 14-month state jail, but that may change depending on the outcome of this investigation. And that's our request this morning, Your Honor.
State.
That's correct, Your Honor. This information is verified, would be exculpatory, and we will be resolved the case when we do verify.
All right, are you available on February 8th?
I believe I'm special. That's probably going to move, but I'm special set on a trial that's going to go 8 and 9, unfortunately,
January 25th.
January 25th.
All right, Ms. Fleming, court sets you for additional docket call January 25th at 9 a.m. Once you sign and get the yellow copy, you're free to go.
Just a minute.
He'll bring it to you.
Judge, we're ready on Cody White.
Cody White. CR 21346 for arraignment.
Judge, Mr. White is charged with possession of methamphetamine alleged to occur on July 1, 2021. It's a state jail felony. We've discussed the range of punishment. This is his first offense. He's aware of that. The state has made a preliminary offer, 3 deferred, $1,000 fine, court costs plus fees, or alternatively 6 months state jail, $500 fine. We're just asking the court to reset this. My client has confirmed that his name is spelled correctly both places on the indictment. He knows that the allegations alleged to have occurred on July 1st, 2021, and authorized me to enter a plea of not guilty and further negotiate with the state on this matter. So we just asked it to reset for pre-trial, Judge.
You take a pre-trial on that 25th day of January, it's too early.
I think that's perfectly fine. I think we'll be very close to a resolution, if not resolved by then, Judge.
All right, court enters Mr. White's plea of not guilty into the record and sets this matter for pre-trial on January 25th at 9 a.m. Mr. White will need to sign his conditions of pre-trial release with the pre-trial release officers after getting your yellow copy, okay?
Judge, we have one that was assigned to me recently. It's not on the docket.
Yeah, it's on Thursday.
Miss Alicia Harris.
All right, so we're gonna call CR 21359, Alicia ALYSHA Harris. Ms. Harris is set on Thursday's docket. She's here and Mr. Ashmore's here, so it's a party. Go ahead and go for it today. We'll take her off on Thursday's docket.
Yes, Judge.
If you'll write her in today's docket.
So Judge,
I believe is she set for arraignment?
she said for arraignment, Ms. Tabram was kind enough to provide the defense with a copy of the indictment. I've reviewed it with my client. She's confirmed her name is spelled correctly in it. She understands the nature of and the severity of the 2 counts alleged in the indictment, both of which involve child neglect and endangerment under Chapter 22 of the Penal Code. We talked about that range of punishment. I've met with the co-defendant, Ms. Beasley, the co-defendant's attorney, Ms. Beasley, about this matter already. So we don't have discovery yet. We have an idea of the matter. She's authorized me to enter a plea of not guilty and negotiate with the state to resolve this matter. We understand this is Ms. Curry's case, so further negotiation will be accomplished when we're not before the court.
But we set it out, you're probably gonna need more time than January 25th. About, so you're specially set the week of February 8th,
Even though that might move, right now it's still a special setting.
about
don't
February 22nd.
I think I'm actually here. Let me double check, Judge. Yeah, that's perfect, Judge. I'm actually back here on Alex Manus.
All right, so we'll set Ms. Harris on February 22nd, 2022. That'd be at 9 a.m. Ms. Harris. Mr. Ashmore, I don't know if Ms. Harris already has conditions of pretrial release signed. If you just go ahead and check in with the pretrial release department for me, Ms. Harris, just to make sure. And if you're good, then they'll send you out and you'll be free to go, okay?
Judge, I think that's all I have this morning, unless Mr. Nichols shows up, and we'll hang around.
Do you have anything this afternoon?
Yes,
You do?
so you can't get rid of me that easy.
All right, well,
Nice try. We'll just,
try harder next time.
Yeah. We'll keep lighting up Mr. Nichols and hopefully we'll be here and we'll straighten that out.
thank you, Judge. May I be excused for a moment?
Yes, sir. Okay, thank you. James Johnson. All right, Mr. Johnson, show that I gave you time to hire an attorney. Do you have good news for me? Who's the one that you're thinking about hiring?
Yes, it's with Richard Smith, but his name is Jonathan Bennett. That's where I'm at right now. I'm just waiting to hear back from him as far as what he goes. And if it's pan out or end up being something to do, I guess the next step is going to be like a title company trying to monetize the show. All I got.
Mr. Manning say when he was, how much time he needed to let you know?
Also, he did say that he was going to be here this afternoon sometime. This morning to see. I told him that I would, sometimes try to get in touch with some other people and see if I can generate some cash. Maybe meet up with some.
So what I'm gonna do, I'm gonna give you till January. It's gonna be the last time I reset you, okay? January 25th. Since you went out, you tried and you worked, then I'm gonna extend you some grace, okay?
Yes, sir.
January 25th. Is Liliana Vasquez here? Let me see who I've got here. Wait. Mr. Thomas. All right, this is cause number CR 21192, State versus Keith LaTroy Thomas, set for pretrial. Mr. Todd is appearing Zoom. Can you see Mr. Todd there on that screen up there? Mr. Thomas. Okay. Go ahead, Mr. Thomason. You're muted. You'll need to unmute that device.
Can you hear me now, Judge?
Yes, sir, I can. All right, we're set for pretrial. Do you have any contested pretrial motions on Mr. Thomas's case?
No, I don't, Judge.
Okay. All right. There being no contested pretrial, the court will set Mr. Thomas then for docket call. And docket call will be that time, Mr. Todd. I mean, you've practiced in this court enough, but just as a reminder, docket call will be the time that the court will be expecting to hear from the state and the defense on whether or not we're going to enter into a plea agreement or if we're going to be setting the case for trial. So are you available on January 25th, Mr. Todd?
Yes, sir. And I do believe I have a case set that day also, Judge.
Okay, good. All right. So we'll go ahead and set Mr. Thomas on that same day for docket call, January 25th at 9 a.m.
Thank you, Judge.
You're welcome. We're going to have him sign a notice and we're going to give him a copy and then he is free to go.
Thank you, Judge. I greatly appreciate you.
Well, thank you, Mr. Todd.
And have a good holiday if I don't see you again, Judge.
Yes, sir. Enjoy that trip. You haven't gone on that trip yet, have you?
No, I leave on the 22nd. So I'm looking forward to it.
Could have lied to me. You could have lied to me. So thanks for rubbing it in. Thanks for rubbing it in. Have a good one.
Bye-bye, Judge.
All right, Mr. Thomas, you're free.
Thank you.
Judge, did Mr. Schmidt's client, John Stinberg, waiver, it's on us that Mr. Schmidt is not here, or is his client here?
Well, I had that Jonathan was going to appear via Zoom on that, but I don't have Mr. Stanberry being here. Mr. Stanberry? No. So I've got Nasa written out, and I've got Jonathan to appear Zoom, but I haven't seen Jonathan.
Okay.
Oh, okay. So he said if Stanberry showed up to let him know he would appear. So
We just thought it was very odd, but one or the other that wasn't here. So.
yeah. All right. So Mr. Sanders is on his way. He was in another court this morning, and so which one's Mr. Laney? You're Mr. Laney, and that makes you Mr. Petty. All right. So we're just going to wait on Mr. Sanders. Like I said, he was in another court. He let us know he was going to be running late, but he's on his way. He'll be here shortly. Okay. So I'm going to stand in recess for a few minutes. So you're welcome to mill about, come in and out, and then whenever we get back going, we'll let you know. Okay. All right. We'll stand in recess for a few minutes. All right, court's back in session. We call cause number CR 21298, Christopher Laney. All right, Mr. Laney is set for arraignment today.
That's correct, Judge. And Judge, we've reviewed the indictment. His name is spelled correctly, laid out correctly. We would enter a plea of not guilty at this time, waive the reading of the indictment, waive the formalities of arraignment, and I believe he understands the punishment range, at least as of, based on what's on the indictments.
Right, court will enter Mr. Laney's plea of not guilty into the record. Court will set setting for pretrial on, do you know when you're going to be back?
Judge, the other one that I did the waiver on, I set that for February 8th. So if that would work for both of these, that'd be great.
Court will set Mr. Laney then for pretrial on February 8th at 9 a.m. You'll give me his notice as soon as you can. Here, Mr. Lane, come on to this table and you can sign the OD. Are you signed?
Oh, yes.
And Mr. Laney, I show that there is a warrant out for your arrest. So we're going to take you into custody at this time, okay? All right, so come over here with the bailiff.
Just to say what it's for.
It's DCW 128. It says possession of controlled substance. I don't know if it's. I'm not sure. If you ask Erin, she has a chance. She confirmed it this morning. So she'll be able to. Do you know, Erin, off the top of your head, if that's a local warrant or out of county warrant?
It shows to be one of our ones, but I can just double check.
The district clerk knows for DC.
That's why I wasn't sure if it was because of once this got indicted, if it came from.
Yeah, I don't know. We'll need to check that out. We'll have a seat here and she'll check that out. Deputy McLeish, if you just want to leave him in here while you check that out, we want to make sure it's not an after indictment warrant or something that's already been cleared or should have been cleared. So if you want to leave him in there. Scotty Petty, CR 21365, set for arraignment also.
And Judge, we would waive the formalities of arraignment, waive the reading of the indictment. His name is spelled correctly in the indictment. We've had a chance to review that, and we asked to have it set for a pretrial.
My court will enter Mr. Petty's plea of not guilty into the record. We'll set this for pretrial on February 8th at 9 a.m. Mr. Petty, I show that you are delinquent in your indigent attorney fees and your bond supervision fees. You're delinquent $320.
I got some money today.
How much can you pay today?
I could pay 40.
40?
Yes, sir.
You're 320 delinquent.
Yes, sir.
That's a long way off.
Yes, sir.
You understand that the court has ordered you to be making payments each month so that you don't fall behind.
Yes, sir.
And that the court could find your bond insufficient,
Yes, sir.
put you back in jail, just leave you in jail until we get the case resolved.
Yes, sir.
If you don't want me to do that, then you need to start coming up with more than
Okay.
$40. I mean,
Yes, sir.
you need to get caught up on what you owe, and then you need to get current, stay current.
Okay.
All right, so
Yes, sir.
get your yellow copy, then you come back here and talk to
Okay.
these officers, and then you go make your payment.
Okay. Thank you.
You think it's what?
It looks like a bond, probably on this case is what it looks like, so.
Let's see, I would have that in my system. That's the case.
It's here. You guys confirm.
It's this warrant, it's this case, it's an after indictment warrant. Let's see it here. It's the after indictment warrant in this case.
So we're good with dispatch.
But hang on, so what I'm seeing here is that this is a 1-4. Mr. Laney, he posted a bond. He posted a bond with East Texas Bail Bonds. No, I'm sorry, with Easy Pickens Bail Bonds. Did that, he posted a $15,000 bond on April 9th, 21.
Okay. I think he should make the clerk's office to check on this. You want me to go grab him or you want to let him look and see what he finds?
He's on bond, so it should. Hang on, so there's a dive in DA 2020.
It is ours. It's a surrender principle. It's active.
Surrender principle. Oh yeah, here it is. Hang on.
That's what just for says, that's okay.
So it wasn't after indictment. After yeah, so the warrant was DCW, so it's after indictment warrant. It should, it probably should say CR 21-298 now, but it doesn't, so. Let's see, the warrant should have been CR 21-298.
Okay, I've included that as well.
But it is. So your bondsman went off your bond. Your bondsman, easy pickings. Yeah, so you'll need to, you want to get that reinstated, you'll need to reach out to them, okay? Nichols, if he shows. We told Daily to do that. So I go do 2 hours.
No, that was too bad.
All right. Court is going to have the following names called for failure to appear in judgment nice eyes. Liliana Vasquez. Jason Nichols. Remind me, we need to call Thomas Meek.
In the hall?
No, with Mr. Sanders. I think he's in the Dallas County Jail. So, I spoke with Mr. Sanders. We're gonna call Jonathan Stanberry. We're gonna call Mitchell Racker. We discussed Thomas Meek. I think we have. I've got confirmed that he's in the Dallas County Jail, but we haven't set it. Is that correct?
That's correct. I think we said that we had set their status today.
All right, so we're gonna set him for pretrial and status again on February 8th. Have her go speak with this firm. The date is up there.
So no Thomas Lee,
The what?
no Thomas Lee.
No, I think he's confirmed in Dallas County. Jail. I know what he's at. All right, court has had those names called. Any response?
No response, Your Honor.
All right, those names have been called loudly, distinctly 3 times in the hallway. They've made no appearance at the time the name was called originally or at the calling in the courthouse. Court will issue judgment 9 sides for each, alias capias. Court will take Mitchell Ragland's NISI under advisement till December 16th. That's Thursday at noon. Court's going to stand in recess until the afternoon session at 1:30.